The First District Court of Appeal is now in session. All who have business before this court draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have just one case on this morning's docket, Shands Jacksonville Medical Center and University Board of Trustees versus Chavez and the Florida Birth-Related Neurological Injury Compensation. Is the appellant ready to proceed? You may.
May it please the court, Christine Davis on behalf of the appellants. I'd like to reserve 5 minutes for rebuttal. Since the court's order directing supplemental briefing in this case focused on a jurisdictional issue, I'll address that issue first. This court asked whether the ALJ has statutory authority to make a NICA compensability determination when the claimant who filed the petition for benefits doesn't actually want NICA benefits.
Yes, it's a little confusing. They file a petition for benefits. They ask to lose in their petition. They win by losing, and then on appeal, they're the appellee. That's why I was slightly confused in calling you the appellant.
Right. Well, and it is confusing, and it all relates back to how the term claimant is defined. But when you review the statute or the act in context, and I think all of the parties agreed that it's been answered that the ALJ does have statutory authority to make a NICA compensability determination. In fact, it's the exclusive entity it's the entity with exclusive jurisdiction to make that determination.
Can you walk through the statute, put aside the cases and whatever else, history and tradition or whatever else, this has been done a million times before. Just look at the statute. Can you walk through and identify which part of the text supports that position?
Sure. So let's start. I'll go in order. There's several unambiguous provisions that are established by the NICA plan, and I'll go through each one by one. The first is that when the provisions of the NICA plan are satisfied and a claim is compensable, NICA benefits are a claimant's exclusive remedy, and a petitioner may not seek a remedy in circuit court.
Sure,
That's
but
section 766.302 subsection 2.
Go backwards. Go back a couple steps before you're accepting the premise that this is a NICA injury.
And it's a NICA injury?
Yeah, and the parents assert right up front, this is not
Right.
a NICA injury.
At least
And they're not-
at least
and
not
they-
in the amended petition.
Right, and the amended petition disclaims, we're not claimants, we're not looking for compensability, we don't want money from the fund, please deny us. So which part of the statute establishes a non-claimant's ability to come in and ask the ALJ to make a determination that they don't have to get funds, or that they are not entitled to funds?
Every provision of the statute that sets forth the exclusive jurisdiction of the ALJ, that NICA compensability must be determined before you can bring a civil action, and that only the ALJ can make that determination, requires them to file a NICA compensability claim before they can go to circuit court.
But I don't see anything,
confusion.
excuse me, I don't see anything in the statute that says you can't file in circuit court unless you file for NICA compensation. What I see in the statute is that if you are in good faith, they don't use that term, but if you're seeking compensation for a NICA injury and you receive it, that, yes, that's your exclusive remedy. I don't see, and certainly don't see in the definition of claimant, that a person rejecting NICA coverage can thereby come into an administrative hearing, disclaim any entitlement to NICA compensation, and have an administrative law judge say, yes, you're right, you're not entitled to compensation. I mean, when you read the briefs in this case forgetting this issue for a moment. Your brief is arguing that they are entitled to compensation. They must receive compensation, and it is their exclusive remedy. Doesn't that seem a little bit like an Alice in Wonderland type argument? Not yours. I understand why you're arguing that. I understand the position that your client has. But where in the statute does it say when a person is disclaiming any entitlement to NICA compensation, they must nevertheless come to the administrative law judge and get a ruling confirming that before they can go to circuit court? I haven't seen it, but
I think it would be the provision that says that if you participate in the NICA plan, and if all of the NICA plan provisions are satisfied, that's your exclusive remedy, just like a workers' comp is an analogous situation. You have no choice. If you have delivered a child with a NICA participating doctor, and who has paid into the NICA plan, and you get in return the no-fault benefits of the NICA plan, then you've been provided notice, you've suffered a birth-related neurological injury as defined in the Act.
But
that is your
hold on.
exclusive
Hold on,
remedy.
excuse me.
Do they assert
They
that the
deny that they suffered a NICA injury from the beginning.
I understand that, but that's not something that the claimant can unilaterally make. That's not a decision the claimant can unilaterally make. And if you
Based on
look-
what? Based on what?
Excuse me?
Based on what?
Based on the Act, which, I mean, I could read the Act
No,
to you, but
yeah.
in the statutes, if you look at the cases where this arises, a plaintiff who doesn't want NICA benefits files a medical malpractice action in circuit court saying medical negligence. The defendant has the right to say, as an affirmative defense, no, this is NICA compensable.
Correct.
It's a departure from the essential requirements of law for the circuit court not to abate that action for a NICA compensability determination in DOA.
Which case says that? How is that a departure from the essential requirements of law? I mean, I know it's happened in
University
this.
of Miami versus MA, University of Miami versus Exposito, D'Souza versus Ortiz.
These are decisions from our court?
Putnam is a decision from this court that recognized that in 2016. So there are decisions from this court that recognize that.
Putnam doesn't hold that a person asserting, medical malpractice, and yet asserting, as the appellees did here, that our client did not suffer a catastrophic injury that qualifies for NICA compensation, must nevertheless go into the administrative proceeding to seek an adverse ruling. That was not at issue in Putnam.
Putnam recognized that they often file a NICA petition as a precautionary first step to a medical malpractice action because that's what they
But this
are
argument
required to
wasn't
do.
raised in Putnam.
Okay. Well, going back to filing an action in circuit court because you don't want NICA benefits, it's an affirmative defense. It's a departure from the essential requirements of law to not abate the action for a NICA compensability determination. The whole reason for the NICA plan and the exclusive jurisdiction and the exclusive remedy is that compensability has to be determined first. Otherwise, you don't get a benefit, you don't get damages in circuit court. That's how the NICA plan is set up. Otherwise, you're eviscerating the entire act. It would be meaningless if a plaintiff, let's say a doctor or hospital, pays into the NICA plan, just like a employer pays into the Workers' Compensation Act or however that works. And that means that you're entitled to exclude that exclusive remedy without regard to fault, and you're protected. So the parents who have a baby with a neurological, birth-related neurological injury without regard to fault get damages, NICA benefits. And then the doctor, without regard to fault, that has to be paid. So that's how the legislature has set up this exclusive this exclusive manner of benefits that you can get under NICA if it's satisfied. It has taken away a plaintiff's right to circuit court, whether they want it or not.
No,
And
the
that's the
statute is, but
legislature's
the
prerogative.
statute's not worded that way. The statute's worded differently than Chapter 440. So the statute here speaks specifically in terms of a claim for compensation, which presumes that someone's coming into the parents on behalf of the child or coming to the fund and asking for compensation, making a claim for compensation, which means that they're asserting that their child has suffered a birth-related neurological injury as defined by statute. That's an affirmative action taken by the parents. What is the basis in the statute? What statute precludes parents from going to court, suing for medical negligence, and saying our child did not suffer a substantial permanent injury? It doesn't meet the definition of a neurological injury. They suffer damages, but just not catastrophic.
Yeah, and maybe I could help clarify, or I don't mean to imply that Judge Sandbaum's question needs clarification, but
Maybe it did.
the example that I think what we're discussing here is that, and these questions aren't necessarily adverse to you. What we're discussing here is a party comes into this administrative proceeding, specifically declares in their pleading, I do not want NICA compensation. First off, the definition of claimant in the statute is a person seeking compensation. Just follow me for a second here, because I think you'll see it's not my place to decide what's adverse to you, but I don't see it as adverse. So what they're seeking essentially is an order from an administrative law judge who does not have judicial authority, precluding your party from asserting an affirmative defense in circuit court. In other words, if they're not seeking compensation under NICA, they say our child has a neurological injury but does not meet the definition in this chapter. Therefore, we are filing a medical malpractice suit. Now, if during the process of that suit, they then began to assert, oh, our client did suffer a catastrophic injury, and they begin to argue along those terms, yes, the hospital or the doctor can assert an affirmative defense that, excuse me, you're arguing that you are qualified to seek compensation under NICA. Therefore, I'm moving to abate this action. We're going to go in front of a NICA administrative law judge. And in fact, plaintiff, you are precluded from arguing that your client is not catastrophically injured. That's the way it's going to work, because otherwise we have to interpret the statute to say a party can come in and specifically say, I am not a claimant, and yet I'm going to assert before the administrative law judge that I want an order declaring that I'm not a claimant. Isn't that possible? In fact, isn't that the way the statute should work?
Well,
In fact, isn't that the way it's written?
it is possible, and it happens that way all the time, which we cited we cited the cases in our briefs where someone who doesn't want NICA benefits does file a claim for medical negligence.
Right.
The hospital or healthcare provider moves to abate because they say, I'm a participating NICA physician. I've complied with all of the provisions of this act and provided notice, and this is a birth-related neurological injury. Therefore, their exclusive remedy is under NICA. So abate this action and go make a NICA compensability determination. What doesn't answer your question, though, is that the statute says that only a claimant can initiate a petition. And you guys are, sorry about that, you are focusing on the definition of claimant, saying that it's a petition for compensation. But that's the only way the statute allows it to be done. And
Well,
so.
let me look at your hypothetical for a second then. I appreciate that. A party goes into circuit court. They file a claim for medical malpractice because their child is injured, which is always a tragedy. But they assert in circuit court, which occurs, as you noticed, as you mentioned, that however our child, our client does not meet the definition of a catastrophic injury. Therefore, we are not required to seek compensation, nor will we seek compensation under NICA. Your client, your hypothetical client, files an affirmative defense and says, yes, the child is catastrophically injured. The circuit court cannot abate that action unless it makes a determination that the child is catastrophically injured.
That's where I disagree, because under the statute, the ALJ has the exclusive jurisdiction.
How is that constitutional?
I mean simply for the purposes of determining the abatement. I'm sorry.
When as you continue to answer, can you also address how that possibly could be constitutional? It seems to violate at least two provisions of the Florida Constitution. Article 5, Section 1, which gives administrative agencies only quasi-judicial power and not judicial power, and also, well, I guess three, separation of powers, and then access to courts. So what you're saying is that by this construct, that a plaintiff cannot sue.
Let me interrupt for just 1 second. Madam Clerk, will you please grant both parties an additional 5 minutes?
Thank you.
But under this construct, a plaintiff cannot go into court and assert a cause of action that is not excluded under the statute, not precluded by nature of some voluntary act of going to the fund and asking for compensation. That it's still precluded. They can't get an adjudication from the trial court until there is an administrative determination that will then preclude or have some preclusive effect in the court with respect to an affirmative defense. And so what you have is you have claimants come in, or a plaintiff comes in, they file suit, hospital asserts an affirmative defense, and the trial court can't adjudicate as a matter of fact, exercise judicial power to determine that affirmative defense. They have to basically outsource it to an ALJ. Just walk me through how that doesn't violate the Constitution.
That is exactly what the legislature required. No one's raised a constitutional challenge here. Other constitutional challenges to equal protection have been raised. The statute specifically says that only an ALJ can make that determination.
On a claim for compensation filed in an administrative proceeding in the first place.
But you have to file that claim.
Only if the judge is ordering it. This all comes because a trial judge orders, like what happened in one of the earlier cases that you cited. This whole idea of filing under protest started with a trial judge who orders the plaintiffs to go to the fund first and base the action. Says you have to go to the fund first, and they say, okay, well, you're ordering us to do it, so I guess we'll do it, and we're going to do it under protest.
Well, right, and that's how that developed, and I'm sure NICA counsel can address this further, but as she set forth in her brief, in 1998, the Florida Supreme Court said that a trial court should have the ability to make that determination. The next year, the legislature changed the law to say absolutely not. It's only an ALJ that has the exclusive jurisdiction to make this determination.
With respect to notice. That was a question of notice.
No, notice was 2006. 1998 was NICA compensability in direct reaction to the McCon decision.
Right.
It wasn't just notice. It's the entire game. It's whether the act is whether the claim is compensable under NICA or not. The legislature made crystal clear that's the exclusive jurisdiction of the ALJ.
Still doesn't make it constitutional. That doesn't answer the constitutional
I don't
claim.
know how to answer your constitutional question because it hasn't been raised and fleshed out. This is what's been going on for decades. The legislature has not changed it. They've amended the statute as recently as 2021. This is just how it has worked. You abate the action. You go to ALJ. The ALJ makes the determination because it's the only tribunal with exclusive jurisdiction to make that determination. And If it's compensable, then the claimant has to accept NICA benefits because that's how NICA works. It's a no-fault statute. If it's not compensable, then they can go back to circuit court and proceed with their action.
So
Right.
the way it works is a party goes to circuit court, in your reading, a party goes to circuit court and files a medical malpractice action against the obstetrician and/or the hospital, asserts that this is not a neurological injury as defined in the NICA statute. Hospital files an affirmative defense. The circuit court, in your reading, has to abate, send it back to NICA. Then an administrative law judge says, oh, that's right, it's not a neurological injury, and sends it back to circuit court. That's what a plaintiff has to do?
It's not what it has to do. It could go to NICA first and ask
I
under protest.
understand that, but in the hypothetical, and in this case, they're saying the child doesn't have a qualifying injury.
In this case, they didn't file it in circuit court first, but that's beside the point. They filed it here first, in DOA first. But yes, if they want to go to file their medical malpractice action and then it be abated to go to DOA to make a NICA compensability determination, that's what the statute and the cases require them to do.
That's
And
not
for-
what the definition of claimant says.
I know. So one thing I wrote in my brief is that if you want to read the NICA Act in context, that is one provision of the Act that doesn't quite make sense because it says you have to seek a claim, you have to file a claim seeking compensation. I agree with you that when you don't want compensation, that's all you have to file the petition anyway, and that's why they filed it under protest. But that one provision, focusing on that one provision negates the entire Act. And that's why we have statutory canons
But
of
it doesn't
construction.
negate the entire act when the party asserts they're not seeking compensation because their client doesn't have a qualifying injury.
And it also doesn't negate the act if the parents honestly believe that their child is, suffered this catastrophic injury that meets the statutory definition and wants the expedited, no-fault compensation that the legislature put in place. They could come and if the parents believe that with respect to their child here, years ago, they could have already been funded.
Right.
But
a lot
they
of them
disclaim
want to go to medical malpractice so they could get more damages and assert a different claim. But the legislature has set out these provisions that require an ALJ to make that compensability determination first.
But you understand that what you're saying is that the legislature put an ALJ in a position of being a gatekeeper for a question of fact on an adjudicatory level. And in a quasi-judicial proceeding, it's limited to that administrative proceeding, and that's okay. What we have here is you're suggesting that it's okay to have an ALJ make a determination of fact that then is going to be binding in the trial court, unless the determination is it's not compensable. But it's still res judicata, or it's preclusive against the hospital. They can't assert the affirmative defense anymore.
All I can tell you on that question is we have not fleshed out and briefed a constitutional issue, but I can tell you that the statute, as far as exclusive jurisdiction and what an ALJ must do, is clear. There's a little confusion about what claimant means, but if you
There's
have
no
to,
confusion, it's unambiguous.
well, but if you want, right, but if you can pull the claimant provision out, then
That's
the
kind
rest
of
of the act doesn't work.
But that's kind of a critical definition, and as far as that making the act absurd, it doesn't. What seems to me to be absurd, at least so far, is that this statute is, and before I forget, Madam Clerk, will you grant appellant another 5 minutes, so appellees will have 30 minutes to split between them? I should have granted more time. I apologize. So the absurd interpretation is what occurs here, is what has occurred here, where I'm reading briefs where the appellee, the prevailing party, is arguing that, yes, the ALJ was absolutely right in saying that we're not entitled to compensation. That's like a landlord going to county court and saying, I'm filing a suit to evict my tenant. I don't want to evict my tenant, and I want you to tell me I cannot evict my tenant. And the tenant coming in and saying, I want to be evicted. That is an absurd use of the process. Parties who want compensation, who legitimately want, as Judge Tannenbaum has said, prompt, limited compensation, file a claim. We want compensation. That's exactly what the definition says.
So
You're
putting-
asking us to take unambiguous language in the statute and interpret it in the opposite manner.
Well, I'm asking you to take the entire act, which is vast majority of which is unambiguous, and construe it in a way that makes sense, which is to read this claimant provision as it has been applied through decades without legislative intervention. And I don't, and it also sounds like the plaintiff would have the right to say, I want compensation or not, when the hospital and the healthcare provider and NICA also has rights. Because if they've paid in and participate, and this is their exclusive remedy, and it's satisfied, they have a right to be limited to that exclusive remedy and not subject to a medical malpractice action and years of litigation.
And that's called an affirmative defense.
Right, but then you get back to going to NICA when you abate.
Yes, after a judge has determined that the affirmative defense must be granted.
Or a jury.
Well,
Excuse me?
Or a jury.
I'll reserve the rest of my time because maybe the NICA counsel can better answer your questions than I am.
Thank you.
Good morning, Your Honors. I'm Tana Story with Rutledge Asenia here in Tallahassee on behalf of NICA. And I lost track of how much time I have, but I think I'm going to take 20
You have
minutes.
15 minutes each.
Okay, I'll take 20 minutes.
You have, if you're splitting, oh, I'm sorry,
Yes.
20 out of the 30, okay.
All right. Many questions were asked, so if you have a specific question, let me know. But just to start with interpretation of the plan, I think you need to look at the reason for the plan in the first place, which was to address the skyrocketing medical malpractice rates that obstetricians were facing, and they were leaving the state. So the intent of the plan was to help reduce those premiums and stabilize the medical malpractice
Is that a
premiums. with respect
legislative intent argument as to how we should interpret the statute text? We should look at the policy and interpret the text based on the policy?
Well, I believe the Florida Supreme Court said that the legislative intent is the poll star by which the plan should be interpreted. And
I thought it was the text, but.
in McCon, the Supreme Court actually raised the same argument that you're raising now. Why is a claimant or a plaintiff foreclosed from pursuing an action in circuit court and not starting in DOA first? The court raised the question about the claimant, that if a claimant isn't seeking compensation, there's nothing in the statute that forbids them from going to circuit court. The very next year, the legislature overruled the McCon case. It stated in the legislative bill analysis that the intent was specifically to overrule McCon. It included language in 766-301 that is exclusive jurisdiction of the administrative law judge, or that these claims should be resolved exclusively in the administrative forum. They added language in 766-304 that no civil action may be brought or maintained until the determinations in 766-309 are addressed by administrative law judge, which includes whether a claim is compensable or not under the plan.
So is it the NICA argument here that a person who comes into before the administrative tribunal and says, I am not a claimant, that administrative tribunal has jurisdiction?
Yes.
When a party says, I am not which they don't say that here, but that's what they're saying. I am not a claimant. I do not want compensation. You think the administrative law judge has jurisdiction?
Yes, and I believe that's been the case. before
Even though the definition of claimant specifically says otherwise.
Correct, based on 766-304 that says no claim shall, or no administrative, or sorry, no civil action shall be brought or maintained until the determinations of the administrative law judge set forth in 766-309 are made.
Do you agree that the parents take the position that their child did not suffer a birth-related neurological injury as defined under the statute?
In this case?
Yeah.
Yes.
And that's their position, that their child, unfortunately, I mean, terrible injuries, but still doesn't meet the definition, right? That's their position.
That's their position, correct.
And also their amended petition asserts that we're not making a claim. We don't want money, and we're not claimants. And in fact, that's what they said. We're not claimants.
Correct.
So then going to the text that was added by the legislature, not looking at the staff analysis, because quite frankly, I don't care what the staff analysis says. Looking at the text in the context, what it says is the administrative law judge has exclusive jurisdiction to determine whether a claim filed under this act is compensable. And then you go back and look at 303, it establishes a plan for the purpose of providing compensation, irrespective of fault, for birth-related neurological injury claims. So the purpose of the fund, the purpose of this act entirely, is to compensate for claims for a child who has suffered one of these injuries. And then the question is going to be, once someone's making that claim, did they actually suffer that injury? How do you jump from that to the position of, well, the legislature fixed all this and excluded the courts from making adjudications on these facts in situations where the plaintiffs are not making that claim?
Well, I believe that you just said the purpose of the plan was to compensate for birth-related neurological injuries, but that's only one purpose of the plan. The other purpose,
I was just reading from the statute.
Well, the other purpose, again, was to address the high medical malpractice rates that were causing obstetricians to leave the state. And part of that was caused by frivolous lawsuits in circuit court, or not even frivolous, just the numerous lawsuits being filed in circuit court against these healthcare providers. And the intent was to provide an alternative, no-fault administrative remedy to provide a streamlined determination either way. Is it compensable or not?
Well, there's three. Go ahead.
Counsel for Appellant mentioned the workers' comp statute.
Yes.
I've been on this court for 18 years. I've never seen a workers' comp claim where the petition filed said, my client was not injured. That doesn't happen. They may go to circuit court and assert that the workers' compensation exclusivity provisions do not apply because of either bad faith as defined by the statute, etc. Here, in this case, the plaintiff, I guess I'll call them the party. They specifically say they're not a claimant. They say that. So a party comes in front of an ALJ and says, I'm not a claimant. I do not want compensation. You came into the proceeding, if I'm not mistaken, or here you're arguing, they're right. They're not a claimant. In fact, you denied the claim, right?
Correct. Well, initially.
Yeah. So, but your argument throughout, right, was this is not a neurological birth injury.
Actually, in the beginning, that was NICA's position based on its experts' opinions. During the course of the proceeding, additional information became available and an additional IME was conducted, or independent medical examination, by NICA's expert,
Right.
who then opined that it was compensable. So NICA did change its position during the course of the proceeding, but on appeal, NICA is not challenging the ultimate finding of the ALJ.
Okay, well, that's interesting. So you've argued both positions, and now you're not arguing against the ALJ's position that it's not a NICA claim.
Correct.
Well, here's what I've heard so far and what I see at this point, listening to the arguments, and we'll continue to keep an open mind. You and counsel for appellant seem to be arguing that there's a provision in this statute that says, regardless whether you're seeking compensation or not, this is a pre-suit clearance statute, and you must file some type of petition asserting that you're either not seeking compensation or that you are seeking compensation. The ALJ will then determine whether you're entitled to no compensation or full compensation under the Act, and only if and when the ALJ determines there's no compensation, then you can go to circuit court. Isn't the more logical and the more textual-based reading is, no, this statute applies to parties who are seeking, as in workers' compensation, prompt, limited compensation. If, for any reason, let's say, for example, here, let's say the party, the appellee injured party asserted, we want compensation under NICA. I assume counsel for appellant would then be agreeing. Perhaps your entity would, the NICA plan would say yay or nay. But if the ALJ in that situation said, no, this is not a neurological birth injury, then they can go to circuit court. That finding is not binding on them. It's not collateral estoppel. They can then go to circuit court and say, we tried to get compensation under the act. It was denied. We made a good faith claim. We did assert we were a claimant. However, it was denied, and therefore we're now in circuit court, and we are free to argue that our child is catastrophically injured, and that will go to a jury. Isn't that the way? Isn't that the proper logical reading of the statute? Based on the text?
I think there's something missing in that analysis, is that at NICA, it's a very narrow injury that's being addressed here. There's the child has to be.
I understand.
Okay, it's very narrow. So we're not saying that they're not catastrophically injured if we're saying
I use that
compensable.
term for short of hand. I understand the definition is substantial, the permanent mental and physical substantial impairment.
Right. So in the limited context of NICA, if that claim is not compensable, then yes, they may go to circuit court and they may argue that the child is injured. We're not saying that they are not injured if it's not compensable. It just doesn't meet that narrow definition. So when you mentioned that when no one goes to workers' comp, no one goes to circuit court and says my client isn't injured. Well, that's a different type of injury than we're dealing with here.
I understand.
And in the NICA case, there's also an exception. You can go to circuit court if you prove a higher standard of willful and wanton. There's also a notice exception that's been carved out judicially.
Here, let me try again. If a party has a child, and this is a tragedy, it's always a tragedy. A party has a child, for example, born with cerebral palsy. They may be substantially physically impaired, but they may not be mentally impaired at all. That occurs. All right. So they go to circuit court. They're suing for the damages for the permanent physical impairment, pain and suffering, all the damages that they think they're entitled to. The hospital comes in and tries to assert, oh no, your child is permanently mentally impaired, substantially, both physically and mentally. The circuit judge has to rule on that affirmative defense. Isn't that the proper way to read the statute? Oftentimes these injuries, here for example, the plaintiff, I use that term so we can follow along, the plaintiff is asserting that the child is not both mentally and physically, permanently and substantially impaired. Why the, I use this term delicately, but why the charade of going before an administrative law judge and saying, I'm not a claimant, I don't want compensation under the act, my child does not meet this narrow definition, as you properly call it, and our judge, I want you to agree, administrative law judge, I want you to agree so I can go to circuit court. You think that's the proper reading of the text?
I agree that it's not artfully worded. I do agree that that is how it has been interpreted for the last 20 years. And I think that you need to...
Has a court said that it's binding on us that a party who asserts they are not, their injured child does not meet the definitions of the statute, must nevertheless go and file in an administrative proceeding, despite the fact that the plain language, nobody can argue it's ambiguous, that the plain language specifically defines a claimant as somebody who's arguing the opposite?
That is what occurred in the Esposito case in the third DCA.
Okay, that's not binding.
No, I will point out that the NICO plan has been interpreted by the Florida Supreme Court numerous times, most recently in the Bennett case, which is binding on this court. And in that case, the Supreme Court cited to
this question was not at issue in Bennett.
But I will point out that in Bennett, they did not see compensation. And the court did note that under 766-301, the ALJ has exclusive jurisdiction to
Sure,
determine
but the court did not address the question head on, what we're asking here.
No,
like
it was
looking
not.
at the statute and asking the questions we've been asking, and surprisingly having both sides kind of on the same side, which is a bit confusing. and you mentioned 301, and yes, there's some legislative findings in subsection 1, but then subsection 2, which is the nugget I think that matters here, it's the intent of the legislature to provide compensation for a limited class of catastrophic injuries, which is what you said. This plan shall apply only to birth-related neurological injuries. Can you please explain to me, if it only applies to birth-related neurological injuries, and you have parents that are saying our child did not suffer birth-related neurological injuries, how they act nonetheless applies, or nevertheless applies?
I believe that's referring to the exclusivity of remedy provisions of the plan, that's
Well, I'm
only
reading to multiple sections. I mean, it's all over the place. That's why I don't understand why this is ambiguous and why the parties are coming in and saying, there's this one provision that's just inconvenient, but for the definition of claimant, this is all fine. No, it's nowhere, anywhere in Chapter 766 that accommodates this process that you're both describing and agreeing that it's okay and constitutional, no less.
I mean, in fact, throughout the statute, I appreciate very much you talking about the narrow class. Throughout the statute, it is based on the narrow class. The narrow class of injuries being that your child is permanently, mentally, and physically substantially impaired, according to the other definitions relating to. In Bennett, which is interesting, I'm glad you brought up Bennett, because in Bennett, I reviewed our decision and the Florida Supreme Court's decision. In Bennett, interestingly enough, excuse me, now I'm slipping into workers' comp. In Bennett, the hospital tried to invoke the rebuttable presumption. And they said, oh no, you can't do that with the Supreme Court. You cannot, that side cannot invoke the rebuttable presumption. And in Bennett, they noted the plaintiff / non-claimant did not want the rebuttable presumption. That's what happened in Bennett.
Correct. That is correct. And that is consistent with the way the statute is written, that the presumption is only available to the claimant.
I agree.
Yeah.
When there's a claimant.
And I don't disagree with, and it wouldn't matter whether I disagreed or not. But yes, only the claimant. But the party here is not a claimant.
Right. I'd like to direct the court's attention back to 766-304 and that provision that no civil action may be brought or continued in violation of the exclusiveness of remedy provisions of 766-303, and that an award, at the last sentence there, an award may not be made or paid under the NICA plan if the claimant recovers a settlement or final judgment is entered in a civil action. And I think that part of the problem with interpreting the NICA plan in the manner in which you're speaking is that if a plaintiff goes into circuit court and sues the hospital and the participating physician and enters into a settlement with one of those parties, then they try to come back to NICA, say they settle with the hospital and the physician tries to say, but I'm immune under NICA, that's not fair, and comes back to NICA to get that determination, the plaintiff or the petitioner could not recover under NICA. It's precluded because they went to circuit court first and tried to obscure the exclusive remedy provisions of the NICA plan. It creates a dual jurisdiction problem and sometimes results in a plaintiff getting less than they are due. And I think that that's what the court was trying to address when it overruled McCon and added the exclusivity of remedy provisions in the statute.
And actually, I think I totally agree with what you said, that a party that goes to circuit court under the plain language of that provision and obtains a settlement cannot go to an administrative proceeding under NICA. But that's not what we have here, and that's not what we've seen occurring in some of these other cases. And that is a person saying, I'm not a claimant. I understand I'm not in any way intending to condemn the practice. I understand how it's evolved. In our Putnam case, we referred to a petition filed, whatever you want to call it, under protest. But the plain language of the statute and the entire meaning of the act is to provide compensation to those parents who are seeking compensation under the prompt, limited provisions of that act. There's not one word in this statute that I saw that said you cannot file suit in circuit court if you are not seeking compensation under this act. Do you see that in the statute?
Specifically stated that way, no. But again, I would rely on 766-304 for that proposition.
But 304, and it gets back to like what our original question was in the supplemental briefing order, is the ALJ's authority. So ALJ, as we all know, is an executive branch officer, and that officer, under the Article 5, Section 1, only has quasi-judicial authority, only has the authority consistent with matters connected with the functions of their office. So with respect to the fund and with respect to a claim on the fund, that officer would have quasi-judicial authority to adjudicate facts related to a claim on that fund. Do you agree with that part so far? Okay. And the statute reflects that. The ALJ shall hear and determine all claims filed pursuant to, these provisions, and shall exercise full power and authority granted to him or her under Chapter 120 to carry out the purposes of this section. So I get it if there's a claim filed, an actual claim, one for compensation, that's a claim on an executive branch fund. It's a fund in the executive branch being administered by an executive branch officer. And in that context, an ALJ has the authority to exercise quasi-judicial functions, make adjudications of fact that will then be binding within the fund within that context. What you're suggesting, I think what everyone's suggesting, is that under the statute and what you're about to quote, is that exclusive authority extends beyond just determining a claim in the executive branch, that extends to claims asserted in the trial court, in the judicial branch. And what you're suggesting, or what everyone's suggesting, is that it's okay and almost required that the judicial branch has to abate the exercise of its own authority and defer to the executive branch to make a judicial, not a quasi-judicial determination, but a judicial determination. Please help me understand that.
I think that we need to also remember that this is, in its entirety, an alternate exclusive remedy, which under the Kluger v. White, it meets the standards. I don't have them in front of me, but I believe it meets those standards and has been upheld in Samples and Coy and other.
For someone who asserts a claim, someone asserting that their child has suffered the specified injury in this statute, then the statute applies. But what everyone here is suggesting is that even if they're not arguing that, the act still applies and the ALJ still has authority. And how is that consistent with the statute, which gives the ALJ exclusive authority to determine claims for compensation under this act for an injury that's defined?
Right. Well, going back to something the appellate said, is the participating physicians and the hospitals have certain rights under this act too. This act provides them with immunity, and they are allowed to intervene into these proceedings and assert that a claim is compensable, and oftentimes prove that the claim is compensable even though the petitioners do not want it to be.
Where does that right appear in the statute?
The right to intervene?
No, the right to have an ALJ determine something that should be determined by the judicial branch, or that they have a right to have an executive branch officer make a judicial determination, notwithstanding the Constitution.
I mean, other than the fact that the legislature granted the ALJ the exclusive jurisdiction to make these determinations, it's not specifically set there.
Well, there's 8 minutes left.
Your Honors, unless there's something specific to the client that you'd like to ask about, I'm happy if you're to defer some more time to someone who represents NICA and is more of an expert than I am on these issues, but I'm happy to address the issues.
I'd like to hear from you.
Thank you.
Thank you.
May it please the Court, my name is Chris Carlisle, I represent the Chavezes. Your Honors, I think, again, I understand, and I think we all understand all the arguments you're making here today. I think the reality is, sitting here listening to it, is you have 3 parties that were participating in a system that is established by NICA, and courts have interpreted those provisions in certain ways over the years. I understand that this court, from the questioning, disagrees with the way that has occurred. But to put three parties who were doing what the courts have indicated they should do, and this process should be, even if, again, it's contrary to the statutory interpretation or the language that you're suggesting, that's the way that we have created this in Florida, and we had to participate in it that way.
But not your clients. Your clients did not participate in this process. Your clients took the position that this whole thing is a charade, it's a joke, but we're going to do it anyway, and we're going to do it under protest. We're going to file a petition that says we don't want compensation. Please don't grant us a remedy. And by the way, just for a good measure, we're not claimants. And so that's not participating in the program. That's rejecting it.
I
playing
agree,
along.
and I agree with the Alice in Wonderland comment earlier
Sure.
that it has created a bizarre situation, but this court acknowledged in the Putnam Hospital case that that's kind of the way it works. And unfortunately, it has worked that way. It can change if either the legislature or the Supreme Court decides to do something about this, or this court can do whatever it wishes with its interpretation of the statute. But this was the situation and the world that the parties found themselves in. And so just as the plaintiff in Putnam County went to a NICA proceeding and said, we don't believe that we're entitled to compensation, they did it because the case law and the interpretation of the
Right,
statute
but tell
has
us the-
required that.
Tell us again the issue and the holding in Putnam.
In Putnam, the issue was, again, NICA contended and filed a motion for summary judgment after the parents filed a claim seeking compensation, not seeking compensation, but as a preventative measure or as a way that had to occur. And the reality was, and I argued this in my supplemental brief, the child clearly did not meet the NICA definition of a child that would be acceptable to that because it was under 2,500 grams. The parties, again, if they had gone to circuit court, they would have been abated and gone back to a NICA proceeding anyway. So the way the system is set up, and I understand
Now,
this court
tell us
disagrees
what-
with it.
Tell us what we held in Putnam.
They went there, you went there and you held. Well, there were two things that happened. One was that the court granted, or the ALJ granted summary judgment because it didn't meet the statutory definition of an injury that was compensable. And then they made a constitutional argument about that, which this court rejected. I'm not saying that Putnam controls this court's decision in this case. I'm suggesting that Putnam explains why this case proceeded as it did below.
I understand, and you know, if we haven't made it clear already,
Yes.
I'd like to certainly make it clear, at least from my perspective. We understand that this has been occurring. We understand that through evolution of the law, through different approaches, there has come a time when parties actually file a pleading and say, I am not a claimant. Because apparently, through custom or tradition and or tangential issues, there's become an understanding that this statute is actually a pre-suit clearance statute for parties such as your clients who assert, which I assume many parents would assert if they suffer this type of tragedy, that my child is injured, but they are not injured under the definition of the statute. And yet the law is going to be interpreted to say, you must go to two different proceedings. You must make almost a sham argument, quite frankly. A sham argument that you're not a claimant, and yet, and I don't mean to be derogatory, just, you know, you're saying that my client is not eligible for compensation so that I can go to circuit court. And again, I hope I'm making myself clear. It's not derogatory, it's not condemnatory, but don't you think that is an absurd application of the statute?
Your Honor, I don't necessarily disagree in some senses that there is.
I mean,
this
aside
thing,
from the textual
because-
question, the
but
crystal
again-
clear definitions, isn't that also an absurd application of the statute?
Again, that's the way this has been interpreted.
No, that's not my question. My question to you is,
that
let me try again.
Yes, Your Honor.
Do you agree that that's an absurd application of the statute?
I agree that there are absurdities that have been inherently created by the way the statute has been interpreted. But again, I raise the argument and go to the catch-22 concept based on Putnam, and again, not controlling in this sense. But let's assume you're a parent, and again, we're not talking about a gray area, tough question about whether or not substantial impairment occurs, but we're saying weigh the child. The statutory definition is not met here. That person, in that case, had to go based on this, and I agree that is absurd in the sense that my child clearly does not meet the statutory definition of this. However, I have to go down this road because if I go to circuit court, I'm going to end up here anyway.
But
And that
you know, I'm
has to
so
be-
glad we had this discussion of Putnam, because not only is that absurd, that is grossly unfair to the parents. I agree with you there completely, 100%. And in fact, they should not have gone to they should not have been compelled, and I don't blame their lawyers or anybody who advised them. They should have been able to go straight to circuit court. We are not asserting this injury, A, because our child doesn't qualify based on weight, and B, because they don't meet the narrow definition of a neurological birth injury. That's the logical interpretation, isn't it?
I don't necessarily disagree, Your Honor. I think there are ways, again, the way this has been handled, and I mentioned putting an attorney or a party in a position potentially of having to make a claim that they don't believe is meritorious.
I noticed that in your supplemental brief and appreciated it.
Which is also, again, I think, a legitimate point. If we've created this bizarre system where even if we are clearly not within the terms of the statute, we nevertheless need to make a claim or a claim under protest, it doesn't make a lot of sense. However, the parties that are involved in this matter did proceed with the way that this has been interpreted and done over many years.
Well, but
That's all I can say.
don't your clients continue to have a constitutional right to go into court, sue your clients as parents of a child that has a serious injury but doesn't meet the definition under the statute? Don't they have a constitutional right to this day, even? Let's assume we determine the ALJ didn't have any authority and, we do something that, vacates the order and sends you on your way. Don't your clients continue to have a right to go into court and have a judge, the judicial branch, to adjudicate that claim and determine it, including if they want to assert affirmative defense, and have that all resolved the way Article 5 anticipates it's supposed to be resolved?
I would not, may I answer your question, Ron?
Please, take your time.
Again, I think I understand the constitutional argument, and as counsel mentioned, we had not briefed that and we hadn't gone through all the different constitutional provisions. I hear what you're saying about that, but the way it's been interpreted with the exclusive remedy provision, et cetera, in the statute, that has been precluded in the past. I don't know if, again, that will change. But I think, again, the parties under this, that is the exclusive remedy. That determination has to be made. If the court, or the ALJ, after appeal, is upheld saying that it complies with the act, then you can't go to circuit court. That's the current state of the system that we're operating in.
Why doesn't it raise a red flag for lawyers if you have a law that is being at least perceived or interpreted? Why doesn't it raise a red flag for lawyers if a judge is sending you to the executive branch to adjudicate a common law cause of action, even when the statute doesn't even cover it? Why isn't I don't understand why there's not more protests, including from your clients on this.
I think, again, Your Honor, after the questioning today, maybe that red flag will be raised with some claimants in the future. But I think that under the current situation and the way, again, we're on appeal trying to deal with what the ALJ did in the process that was followed here. We didn't bring the claim originally and didn't do this. This is where we are at this moment. I understand what you're saying, but the parties were playing on the field and with the rules that have been established, and that's all I really
aren't your clients in the same position, whether, let's just say we affirm the ALJ's determination versus if we vacate the ALJ's determination and say he didn't have authority in the first place? Aren't your clients in the same position either way in terms of being able to sue in court?
I would suggest that if it is vacated and it's remanded back to an administrative law judge for other consideration,
not remanded,
if it's no jurisdiction in the first place,
right?
That creates an interesting question that, again, will have to be dealt with if that occurs. But
Under the hypothetical question just posed, your client wins either way and can go to circuit court. Which is exactly what you ordered in your initial brief.
we would like
I
to
mean,
go
the
to-
answer brief.
Yes, Your Honor. Thank you very much, Your Honor.
Thank you.
I will attempt to make 3 points that may or may not answer the questions that the court has, but this is the best I can do at this point. So, the way I understand the court's question is, or the court's opinion, is that we're putting all the eggs in the parent's basket. It's not all, the eggs are not all in the parent's basket. They don't get to make that determination just because they feel like they should go to circuit court. The legislature made that determination. If the legislature wants to change that, then the legislature can change that. And one thing the statute makes clear that I think if it's inconsistent with the definition of claimant or not, the ALJ has exclusive jurisdiction. I'd like to, in Putnam, which you raised, if I can, of course I had it marked and now I'm going to have to find it again. This court recognized in Putnam the rights of the hospital and not just the parents who decide unilaterally that their claim should not be decided under NICA. If you just give me 1 second, I did just have it. Putnam recognized a hospital has standing because it has a direct economic interest in avoiding being pulled into civil litigation over liability for injuries that are covered by NICA. Absent standing, hospitals and physicians would be unable to defend their interests and avoid potential civil liability, a result the NICA statute does not support. Also, in the NICA Act, it contemplates the parent's right to go to circuit court. There's a statute of limitations provision in the NICA statute that says if you file your petition for benefits under NICA, your medical malpractice, civil medical malpractice action is tolled until the NICA determination is resolved through the pendency of an appeal. So it's not just that the ALJ can make a decision and everybody's stuck with it. You can appeal it, and this court will decide whether they agree with it or not. So you have an appeal, and it's all decided, and then you either go back to circuit court or you have compensability under NICA. So if you file your petition, the statute of limitations is tolled. If you do it the other way, and that's this court's decision in Macri from 2009, if you do it the other way and you file a petition in circuit court, a complaint in circuit court, and 5 years later a defendant says NICA compensability, the NICA compensability determination is time barred because it's a 5-year statute of limitations on NICA. So if the ALJ determines that it's compensable, yet you chose to go in circuit court first, then it's a lose-lose. And that's why this court said you're doing it at your own risk.
But that also contemplates, you just highlight the sham that this, and I know everyone's just playing by what they understood cases to say, but it really does, it's just another way of saying Alice in Wonderland or whatever else, that from just looking this on paper, it just seems like a sham. Everyone's kind of going through the motions because they feel like, well, we have to, and so we'll do these things, but we really don't believe it, and in fact, so to justify or order on your clarification question about whether we're going to ask any other questions outside of jurisdiction, in this case, you have both parties that stipulate to a record. There actually aren't any live witnesses, and you just have an ALJ looking at a bunch of paper and making a determination that then is going to be binding in some way in the trial court.
Subject to this appellate review.
Right, and then you're asking us to do the same thing and review the experts and determine whether one or the other is better or worse, or whether the ALJ got it right. Is that really what the statute contemplates in this? Or is it what everyone's kind of just made up trying to accommodate what courts have done in the past?
I think you're focusing on the definition of claimant, I understand. Read the context of the statute in a whole, including what the legislature did And it's made clear it's the exclusive jurisdiction of the
For
ALJ.
claims for this injury.
I don't
Yeah.
know what else we can say other than the legislature fixing it themselves if they think it's a sham or not working properly. Because if this court holds that the ALJ does not have exclusive jurisdiction to decide whether a claim is NICA compensable, that's in direct conflict with the express language of the statute. So we have an entire statutory scheme that says how this plays out, and that the ALJ has exclusive jurisdiction subject to appeal to this court.
But you're
case law is-
challenging the ALJ's, here, you're asking us to vacate or set aside the ALJ's order in this case. That's the
Yes.
relief you're asking for.
Yes.
What our question suggested is the ALJ doesn't have authority to issue the order that he did, which would result in a nullification of the order. Yet, you take the position on behalf of your client that, no, the ALJ did have jurisdiction, but we still want you to vacate or set aside the judge's order. And so it's hard to square that.
I don't
Those
think
two
I'm in a
positions.
position to tell this court to ignore the plain language of a statute.
I will say that regarding the statute of limitations provision, which I reviewed, I think that there is a reading of this statute that the way it works is when a party is in good faith seeking compensation, and they seek compensation, they assert they're entitled to compensation under the Act, and it takes years, hopefully not as many years perhaps as circuit court, but it takes some time for the ALJ and this court to decide that no, under the Act, you were not entitled to compensation after all. The statute of limitations is told.
So,
And that's a logical, appropriate reading of that provision. In fact, when I saw that provision, I realized that, in part, that's the way the statute works. Not just, I'm not asking you questions anymore, so.
well, if I could just, and I understand that you're not bound by the third DCA, but the Exposito case addressed the statute of limitation questions and the conundrum that comes in the fact that it tolls if you file a NICA first. It doesn't toll if you file in a medical malpractice action first, even though you have 8 years. And it says, if the ALJ determines that the claim, though untimely, is otherwise compensable, the claimant is not only prohibited from pursuing the NICA claim under a time bar, but would also be prohibited from pursuing a civil action because a finding of compensability renders a NICA claim the exclusive remedy. That's what the plain language of the Act says. If this court is to write an opinion that the ALJ doesn't have jurisdiction to make that decision, I don't know how that's not contrary to the express language of the statute. And I don't think, especially because of the no-fault system that NICA comes up with, that everything is in the hands of the plaintiffs to say whether or not they believe. Hospitals have the right, too, to say, I participate in this program. This is a compensable injury under NICA, and therefore I'm entitled to raise this, and the statute gives them the avenue to do that in DOA and not the circuit court. That's at least how the law is right now. So,
Thank you both for your arguments. Court's in recess.
All rise.